Thank you so much, Madam Chair and members. When employees discuss workplace matters such as discipline or grievances with their union representatives, they often believe that these conversations are confidential. However, current state law does not explicitly prohibit employers from compelling employees or their union representatives to disclose what they discussed. AB 340 makes the communications between an employee and their union representative confidential, which is essential for fostering trust and ensuring effective representation. With me today is Randy Perry with PORAC and David Mustagi, legal counsel into PORAC, and I'd love for them to say a few words.
Yes, witnesses, you have 3 minutes. Thank you.
Thank you, Chair and members. Good morning. I'm David Mustagni on behalf of PORAC. I'd like to first talk about what this bill would do. AB 340 codifies existing PERB case law to ensure that communications between employees and their union representatives remain confidential. PERB has long held that it's, quote, beyond dispute that an employer's inquiries into discussions between employees and their union representatives have a tendency to chill the protected activities of both the employees and the representatives. This bill levels the playing field for public employees by making this protection universal across all public employers under PERB's jurisdiction. It accomplishes this by making it an unfair labor practice for an employer to require union representatives to disclose information from these communications with their members. I want to also address what the bill doesn't do and the contentions of the opposition. The opposition's main concern is that this bill establishes a privilege. That's not true. This bill is modest and it's balanced. There is no privilege that's created. Rather, it just codifies this limited protection against a public employer compelling disclosures regarding communications made in confidence between a representative and a member of that labor organization in connection with any matter within the scope of representation. This bill doesn't alter the evidence code. This bill doesn't apply to criminal investigations. No privilege would exist in any civil or criminal proceeding where someone other than the employing agency or its agents seek evidence regarding these communications. It's only enforceable through PERB, which is a very important point, as an unfair labor practice against the employer. In short, it simply codifies existing PERB case law. There's also a contention that it will interfere with investigations, and just if I may briefly, it doesn't in any way. If the representative is a percipient witness, then the confidentiality wouldn't apply. It's limited strictly to those communications. It also incorporates sections of the Peace Officers' Bill of Rights, which expressly state that the representative can't be a percipient witness to the underlying investigation.
Thank you.
Thank you.
Madam Chair, members, Randy Perry on behalf of PORAC. I would just add that some of the opposition said, you know, if PERB law is already, or case law is already clear on this, why do we need to codify it? Well, the fact that all the opposition is here today of the employers still opposing this bill, then I think there's a clear question as to whether or not it's illegal to question the representative. Thank you.
Thank you. Are there any other witnesses in support? Please step forward, give your name, organization, and your position.
Cassie Mancini on behalf of the California School Employees Association in support.